So the first thing to do is to figure out what you have. If you're starting a company, you need to figure out who's bringing what to the company. In a lot of small companies, people don't keep very good track of their intellectual property assets. So if you give somebody the responsibility to do that and kind of keep a running inventory, it'll be a lot easier. And when people talk about intellectual property, they usually mean patents, trademarks, domain names, trade secrets, know-how too, really, even if it's not a trade secret, because at some point if you have a lot of know-how, even if it's in the public domain, there are little tricks to making it work that probably aren't. And copyrights. Copyrights are something you need to be particularly careful of if you're working with software, because if you're incorporating other people's code into your software, if you're using open source, you may be subject to licenses of the open source software that you have. And that's a place where we see lots of problems now, particularly with small companies, because they don't know what open source they've used. And there are ways to find out, go back and find out, but it's not a very quick or efficient process. So if you do that on the front end and keep an inventory of the license agreements that you're subject to and try to make decisions about what open source you're going to use, you'll be in a lot better position. So we can start on ownership of intellectual property rights. As I go along, if you have questions, go ahead and ask. I don't mind being interrupted. As I said, this is the place where you can have the most problems with a startup company. If you have people who are bringing different intellectual property assets that they've created before the company actually gets going to the company, and you don't have written agreements that assign those to the company so that the company owns the rights rather than the individuals, if you have a falling out, you'll pretty much kill your company because nobody's going to be able to clarify the ownership, and you won't be able to use that intellectual property going forward. And you see that happen over and over again where founders have a disagreement about what the deal was because they never actually wrote it down. So if you're going to be starting a company, that's the thing that I would do with the founders, is sit down and agree on what the deal is. And if you attended Allison's session this morning, she probably talked about what founders' agreements usually look like. If people are putting in money or intellectual property assets or just the agreement to work for the company, there's usually an allocation of what equity interest they'll have in the company and who's going to get the rights if the company doesn't succeed. A lot of times inventors will have a reversion right if the company doesn't last more than a year or some period of time, or until at least you get a first round of financing. So you want to clarify who owns the intellectual property assets. You'd prefer that to be the company and not have to worry about it going to anybody else. So I'm going to talk about the different rules for different kinds of intellectual property because they aren't consistent, and you need to be aware of the inconsistency when you're creating intellectual property rights. And then what you can do to bring ownership of that into one entity, what you need to do just procedurally with whatever recording body you need to record the interest with, which is a little bit tedious, but it's really simple, and if you know it, you won't make those mistakes. And then what you can do when you're dealing with other people to make sure that you don't lose rights inadvertently. So patents, the rights in a patent or an invention are owned by the inventor. So if you have co-inventors, they each have an equal right to the invention in the absence of an agreement to assign it to somebody else or to an entity. And what that means is they can independently exploit the invention. So if you have three founders of a company who are all co-inventors of technology and you don't have a written agreement to assign it to a company, and you have a falling out, each of those three is going to have independent rights to exploit the invention. And the problem with that is there's no duty to account for whatever money you make when you exploit the invention. So you have three people who would be driving down whatever royalty you might be able to generate from the technology. So,
Find that it's really worth it to get a patent.
You can patent almost anything. In fact, I could show you some that I patented that are almost anything. I think the test I usually use is not whether or not you can get a patent, but whether or not it adds any commercial value to the company. So one of the things you want to look at is, does it give you a competitive advantage? Because patents can be really expensive. So later on I'll talk about what you can do to develop a strategy for patent filing. But the first thing you want to do is identify ideas that might be patentable. And the statutory test really isn't that difficult, and actually getting it through the patent office isn't that difficult. In fact, the more trivial the invention is, the easier it is to get a patent on it. If you have something that's really new, the patent office is going to say, well, you really shouldn't have a patent that broad, and they'll fight you. But if there's lots of prior art and you can very narrowly define it, it's usually pretty easy. So the statutory test is that it has to be non-obvious to somebody who's skilled in that area. That isn't very helpful. What you want to look at is, does it give you a commercial advantage? And I think the best test, for me, at least the way to conceptualize that is, when I look at what somebody else has done, is it the sort of thing where I say, gee, that's pretty clever? And that's not a bad test, or I wish I'd thought of that, because I think what that does is give you an indication of whether or not it's non-obvious and whether or not it has some utility. So that's the first test I'd start with. And then you have to identify whether or not it's going to be the kind of patent that will give you a competitive advantage. And part of it depends on the stage of the company. Sometimes when you're early on, it's more important just to file patent applications to protect what you have, even if you're not sure what the value is going to be at the end, because what you don't want to do is inadvertently give up rights. So if you start selling a product or announcing that you're going to sell it and describe what it does, and you haven't filed a patent application on it, it may be too late later to file it when you find out that it's a really great idea. So on the other hand, if you know exactly what your product's going to look like, it's much easier to pinpoint the features you want. So I'll talk about that a little bit later on. But the place to start is this a technology or an element in the product that if we stop people from doing this, it's going to be really hard for them to do it in an alternative way. And how hard is it to engineer around whatever it is we've patented? So that's, yes?
Well, we're still here. In a collaborative environment, how do you determine who's a co-owner or co-patenter, co-inventor, if you will? If 99% is one guy and 1% might be somebody else.
Well, there isn't an allocation on that basis. If you're a co-inventor, you're a co-inventor, and you have a right to the whole, unless you assign it to somebody else, whether or not you contributed 1% or 99%. But
in a room, and how do you know if your concept was part of that patent or led to part of the patent?
I think you have to look at it and say, how much creative input did somebody have into the idea that resulted in the invention? So if you have an inventor who asks somebody else to make the parts or to put it together, and they just do what they're instructed to do and sort of the steps that anybody would know, that the person who's being instructed wouldn't be an inventor. On the other hand, if that person comes back and says, it doesn't work this way, maybe we ought to try this, or I know a better way to do it. And I don't think there's a good way to identify that other than just in good faith who contributed to the invention. And it's important to put down the people that are really inventors, because if you don't put down the right inventors, the patent will be invalid. And if you put people on who aren't inventors, the patent will be invalid. And so you can't just list anybody who participated without doing some inquiry. And sometimes people get hurt feelings over that, but you have to be pretty careful about it. And it really is it's a statutory requirement that if you mess it up, you're out of luck. And if you put the wrong inventors or not all of the inventors on a patent, it'll be subject to challenge. I had a case once where It was a magnetic card technology, early magnetic card technology for opening doors or locks or whatever. And the inventor on the key patent was someone who'd never had any technical training, and he had a partner in his business who had worked for IBM, and when the patent application was filed, only the one who didn't work for IBM was listed as inventor, even though he didn't have any technical background. And they sued our client for royalties on the patent, and when they were deposed, they both said, well, we collaborated on it, but the one hadn't been listed as an inventor because he was under an agreement with IBM. So that case went away really quickly. It's nice when you're on that side of it, but there's a real temptation not to list people as inventors if they leave a company, and you just can't do that. That's one of the reasons you want to make sure you clean it up on the front end and make sure you have assignment agreements in place before something's created. So copyrights are a bit of a mirror image. Maybe it's a distorted mirror image. You don't have to get an assignment of a copyright from an employee, because if they're doing it in the course of their employment, the company owns the rights. But if a person's not an employee, if you don't get an assignment in writing, the consultant or the third party is going to own that, and you will only have a license to use it for whatever purpose they developed it. So if you contract with someone to develop copyrightable subject matter, whether it's advertising materials or designs or software, and you don't get a written assignment, they will own that, and you'll just have a license for the use that it was developed for. And in the case of copyrights, there's a duty to account if you have co-developers, but that won't help you if you've paid somebody to develop it for you and you haven't been involved in the development yourself. And this is something that's overlooked all the time, too. I had a company once where a founder developed some code, and it was incorporated into another company's product, and it was the early technology for monitoring internet performance. And he never signed an assignment agreement with the company. He ended up forming his own company with that code. And the other company got what they needed, but he got a company that he sold for a lot of money, $150 million. So, but he was conscious going in that he wasn't going to sign the agreement unless they forced him to. Got lucky because nobody followed up on it. If you're on the other side of that, you really want to make sure when you enter into agreements that people actually sign an assignment agreement when you contract with them to develop something for you, because they'll always do it at the beginning if you're going to pay them, but you lose leverage if you wait.
So if they're gone and you get a signed form for the patent office, you can attach the previous early assignment, and
You can sign their employment agreement, or you can attach the employment agreement, and the patent office is used to that. In fact, they're more used to it than they used to be after the dot-com bust. There are lots of inventors that left companies and didn't want to sign assignment agreements, but if you had an employee agreement, you could just file that with the patent office. And it happens fairly simply. It's kind of a pain in the neck because you have to, at least from my side, because I've got to go file all the extra papers, but it's just a formality. Trademarks and service marks are a lot easier because they're just owned by whoever it is that uses them. So if a company uses them, you're not going to lose rights to an employee or to a contractor. Trade secrets, you have to be careful, because if you don't take pretty stringent measures to protect them, you'll lose any rights that you have. So I guess in summary, it's just a lot easier to clean this stuff up on the front end, and some of the agreements that are in the books that I distributed cover this. So there are employee confidentiality agreements, and there are consultant agreements, and they're just blanket assignments, I think, in those materials that you can use as samples. Yes?
Is it pretty expensive to get trademarks registered?
No. I mean, I guess it depends on the trademark. Pardon me? No, a patent's usually a lot more expensive because, I mean, there's a lot more work involved in getting a patent than in registering a trademark. So with trademarks, as long as the mark is not too close to somebody else's and it's not too descriptive, which means that, you know, if your trademark tells somebody what the product does, it's harder to register the trademark. If it's very distinctive, it's usually pretty straightforward with the patent office, unless it's very close to somebody else's prior mark. Patents, I mean, there's a range of costs, but it's never really cheap. I mean, just as a ballpark, if I do a federal trademark registration, the cost to the client's going to be between $2,000 and $4,000, start to finish. If I do a patent, the start to end cost, in most cases, is going to be between $20,000 and $30,000. If it's really complicated, it'll be more. So I guess it's an order of magnitude different.
It's like a young company. Maybe you have a name and you don't know if it's going to take off or not. Do you think it makes sense to get that trademark early on?
I guess it depends on what kind of a product it's going to be and how distinctive the name is. If you think the name's going to sell the product, so it's a consumer market and it's something where people are going to recognize that name, then I think it makes sense to do it. In a technology business where you have a limited number of customers, it's probably less important, and if it's not a very distinctive name, I don't know how much value there is. And to a certain extent, you can do it yourself. You can go to the Patent and Trademark Office website and file an application yourself electronically, or actually you can send it in. They charge you more now to mail it than to do it electronically, but they take credit cards. So if you have a really great name and you know how to describe it, what your product's going to be, it's worth the $325. It might be worth $3,000 to pay somebody if it's a little more complicated.
If you use a TM, don't you have a lot of time when you go to the marketplace? Do you have TM on everything until file it later?
Well, TM just means that you claim that it's proprietary, and you get common law rights when you put TM by the name. What you don't get are the rights that come with a federal registration, which are pretty substantial. So if you use TM, you have common law rights that are related to your use of the mark. So if you haven't really done anything yet in selling a product or offering a service, or if it's only in a very small area where it's being offered, your rights are going to be limited to that geographic scope. But if you file with the Patent and Trademark Office, you get a nationwide right from the day you're filing. So it's as if you've used the mark every place in the country as of the filing date, provided you get a registration. And that can be really important if somebody else adopts the same or a similar name around the same time you do or just after you do, because you can point to your filing date and say, I have a federal registration, your mark's the same as mine, and your product is really similar to mine, you need to stop. The other thing that a federal registration helps you do is persuade other people to stop, because if you have a federal registration and people use a mark that's pretty close to it for similar goods or services, the test under the law is whether or not it's likely to be confused, or there's a likelihood of confusion, and I think it's probably the most intuitive part of intellectual property law. If it's too close and you think it's confusingly similar, that's probably a good indication of whether or not it's too close. If you have a federal registration, 90% of the time people say, sorry, I didn't know, I'll change. And if you don't, 90% of the time they'll say, so what? Show me why there's a problem. So it makes a big difference in terms of ease of getting other people to stop. So I think it adds a lot of value if you're going to be selling products or offering services if you get a federal registration, even though you can rely on common law rights. Because the cost of trying to make somebody stop, of having me send them a letter and follow up on that, and when they don't respond, send them another letter, is going to exceed the cost of registering it pretty quickly. And the results aren't nearly as good. These are some different situations for things you ought to be aware of when you're looking at intellectual property rights. It's really easy if you know what the intellectual property is. So if something's already developed and you're acquiring a product or a right, you can do a 1 or 2 page agreement that assigns the rights, and that's all you need. All you need to do is be careful that you really define what it is that you're buying. Employees in California can get rights, or you can only take a certain amount of what they create as your right as an employer. So if it's done on company time or with company resources, or relates to what the company does, or if it relates to what the company's demonstrably anticipated business is, then you can get that contractually. So most employee confidentiality assignment agreements require an employee in California to assign all of those things to the company. And a lot of times they'll ask employees to also disclose if they have any rights that they think are excluded from that. So that if one of your employees thinks that they're going to own something, at least you get notice of it and have the opportunity to argue with them about whether or not it belongs to your company. In most cases, things that employees develop while they're working for an employee are going to relate to the business. So if you're on the side of being employed by a company and you're developing anything that's arguably related to what your job responsibilities are, you won't be able to commercialize that unless you get your current employer to agree that you own those rights. Yeah.
So relate, how do you define that relate? I mean, the company can say that in the future I'm going to do it too if it's successful. So how do you define the relate?
Well, I don't think there's a good definition. I think it puts employees in a really bad position, frankly. So if you're going to develop something, the easiest way to do it is to leave your current employer before you develop anything at all, because you'll have a question about ownership. And if I were the employer, I'd assert those rights, because there's nothing that'll kill a company quicker than having a claim that they don't own whatever it is they're starting the company around. So what does relate mean? I think it's pretty broad. That's actually something you don't see litigated very often in California, and I think that's because the employees always lose. I've always wondered what would happen if a company like Lockheed tried to enforce one of their agreements against an employee who developed something that related to the company's business that's completely different from what they're doing. So that case hasn't happened, but under the law they're entitled to get that. So IBM, GE, do they own everything that relates to their business from California employees? I don't know. But I wouldn't take the chance if I were the employee planning to start a new company, and I think you have to be willing to either go to your employer and tell them, I'm thinking about developing something, I'll tell you what it is, and I want to exclude it, and I want a written agreement that it belongs to me, or leave the company before you develop it.
Sometimes things are more simplified. For example, you can always file for patents, right? That doesn't take too much time. So it's okay to file patents, for instance, people are working for Intel.
Well, it's just that Intel will own the patent.
And then the employee actually invents some, let's say something, like microwave oven, okay. New way washing machine. And he patented that. Well, so he patented by himself, right? So all it's on Saturday, Sunday, prepare that, right, and then mail it. Pay everything. Who owns that?
Well, the last time I had a problem with a washing machine, it was the control board. So I think if I were the employee, I wouldn't waste any time developing something without an agreement that doesn't belong to the company. Because I think if there's any way that the company can claim it, they will. And you're just acting it.
Medical advice.
Well, there's not a bright line there. I'm just telling you, my experience is, if you're not willing to leave the company, you'll never get it off the ground. If you're working for somebody else, and your employer is not willing to agree that you own the rights for this new stuff that you're developing, nobody's going to put money into a company on that basis. And I've seen that over and over and over again. So the only way it works is leave so that nobody's got a claim to it.
Let's say Intel, he invented the driving washing machine. But in 5 years later on, he found that, hey, that's a good idea. And then he quit the company and say, in 5 years ago, I applied a patent, even though I'm an employee of Intel. And I still think that that's these employees.
So he filed the application while he's working for Intel?
Yeah.
It's a loser. I just wouldn't do it. Nobody's going to put money into that company. I mean, that's the way it is. I mean, that's the thing that'll scare off investors the quickest if you don't have a clear right. And if somebody sees that you developed something while you were working for someone else, and you don't have a written agreement from your employer saying, we acknowledge that we don't have any rights in it, 90% of people won't talk to you anymore after that. So it's just...
If you left the company and then you apply for patent, will the employer came and say that's interference or technology you then sue the company and then you get the patent? Would that be a case?
Well, I think it depends on how long it is since you left. If you file a patent application the week after you leave, no, there's no bright line there.
Okay.
Case-by-case determination. I work at Stanford in the licensing office, and this comes up a lot, and it's really a case-by-case determination. But yeah, it's a big black cloud over the IP, and the investors here are very savvy, so they're good at asking who owns the intellectual property.
And if you're still employed by somebody, I mean, it's a giveaway. They'll say, where's your employment agreement? Well, it says that you're signing all your rights. Tell me why you think you own this instead of your employer. And, you know, they'll say, let's go back to your employer and talk about it.
Industry, and then you buy a patent for another industry. Like if you are working in software and then you apply a patent in biotech.
And you know, she's right. It's case by case, but every case is a loser. I just wouldn't do it. I mean, I've been doing it for 20 years. They're all losers. Every one of them. I mean, you can rationalize it, but it doesn't work. It's because your employer's got a legal budget of X, and you've got what? And nobody's going to put money in. That's why it's a loser. So you might be right, but you'll never get a chance to show anybody that. The place you really need to be careful about rights you develop is where you're having a joint development arrangement. So if you're doing a deal where people are putting different elements in, you have to be very careful about thinking ahead and trying to identify what it is that might come out of the development and how that might be valuable to you. A lot of times, if you can anticipate where the technology is going to go, you can get the rights that you need and maybe not have a co-ownership problem where there's no duty to account. So what you don't want to do is have some technology developed that's really key to your business, and your co-developer can go license that to your competitors. So that takes a little bit of thought about where the technology might go. The rules on where you record title changes are inconsistent too, just like the ownership rules. Patents and trademarks, you can record them in the Patent and Trademark Office, the Copyright Office for copyrights, but only for registered copyrights. So most works are not registered. Copyright attaches when you create a work. So anything you write or design, the copyright attaches whether or not you put a notice on it. But unless you record the copyright with the Copyright Office, you can't record title changes. So you have to register it first. And that's something that makes a lot of sense if you have designs or software to register it at least in the major embodiments. So if you have major revisions of the software work, it probably makes sense to register the copyright with the Copyright Office. And there's some other reasons you want to do that too, because it gives you a lot better right to enforce. Trade secrets, there isn't any place to record title changes. So if you're acquiring trade secrets, You want to get people to warrant they haven't sold them to anybody else and they really own it, so that you at least have a remedy against whoever it is that's selling it to you. The other thing that you want is a detailed description of what the trade secret is. And if you're selling intellectual property rights and you don't perfect an interest in it, if there's some payment remaining to be made, you haven't perfected a security interest. For example, if you're getting payments over time, if you don't record in the right place, you'll just be an unsecured creditor, which is a really bad thing if the company goes bankrupt because you won't get anything back. So you want to make sure that you take a security interest if you have a payment over time, whether it's a royalty or just a flat payment schedule. And if you record it in the right place, if you don't get paid, you can take the work back. It's pretty simple to do this, but what you want to do is record both in the federal body that records them, whether it's the Patent and Trademark Office or the Copyright Office, and you want to record with the Secretary of State's office. That's a UCC1. And that's something you ought to be aware of. You don't have to know the mechanics of it. You can find the lawyer to do it. But if you don't do it, you really have a risk that you're going to, if the company you've licensed it or sold it to isn't doing well, you won't be able to get paid. So that's something I see over and over again, that people haven't recorded security interests and they just lose whatever it is. It's really frustrating if you've developed a technology and you thought you were going to get a royalty stream, and it turns out that you don't get anything and you're an unsecured creditor.
I've done a couple of contracts where we license technology out. In the contracts, they say, if you fail to pay, we can basically pull everything back. Is that not enforceable unless we've also registered it?
Yes. So yeah, you theoretically get everything back if they don't perform. So your remedy would be against the company that you have the agreement with. But if they go into bankruptcy trustee doesn't care. So you have to have a security interest. So when you're negotiating agreements, there are a couple of things you can do to be careful you don't lose rights. With employees and consultants, make sure you get a written agreement for the rights. And those usually cover confidentiality as well as an assignment provision. And as we discussed before, if you have an employee who leaves or refuses to sign the rights over, you can go to the patent office and just show that agreement, and there really isn't a question about ownership. If you don't have it, it's a lot more troublesome because an employee who doesn't have an agreement to assign might have rights to the invention unless they're employed to invent. You don't want to be in the position of having to demonstrate in court that somebody was employed to invent, even though it may be obvious. It's way easier to get them to sign an agreement when they come to work for you. Copyright notices and registration are really simple, and they're a really easy way to protect copyrightable works like software or designs. If you put a copyright notice on a work like on the front of this booklet, what that does is give people notice that they can't copy it without your permission. And you can copy these ones. I just put it on there to illustrate the point. But it's really simple. If you ever forget how to do it, look at the front inside cover of a book. It'll have a copyright notice, and it gives you a lot of rights to prevent people using your work without or with a defense that it's just fair use because they thought it was in the public domain. Registering a copyright gives you a lot more rights. So if you have an important work, it's worth going, either having somebody register the copyright or do it yourself. It's pretty simple. You can go to the Copyright Office website. There's a 2-page form. You fill it out. There are instructions. There's a $20 filing fee, and you have a deposit requirement. So the second time you do it, it's really easy. It's kind of like putting together toys on Christmas Eve. The second time, it's really easy. It's a little tricky with software. You have to know how to do the deposit, and it's explained, and if you kind of go painfully through it, you get it right. But what that does is give you the right to get statutory damages. In copyright infringement cases, it's often hard to prove that you've been damaged or whoever took it earned any money off of it. So those are the two measures of damages in a copyright suit: lost profits or somebody else's profits that you can recover. If you can't prove that, if they just posted it on the internet and haven't made any money, and you don't have any sales, it's hard to prove either of those. So you can get statutory damages, which are up to $20,000 per infringing act. So the recording industries use that pretty effectively. If you post a recording, the damages for each time it's downloaded are up to $20,000 if it was innocent, and $100,000. So suddenly you have a lot of leverage because whoever it is that copied the work has a lot of exposure. The other thing you can get if you register a copyright is attorney's fees. So it, just like having a federal trademark registration, it really changes the dynamics of whatever the infringement issue is, because suddenly you have a lot more leverage and people will be much happier to concede and stop. And there is a trade secret notice in these materials, I think, with the copyright materials. If you're providing trade secret information to somebody else, you want to make sure that you mark it as confidential. You keep an inventory of what you give to other people and mark everything as confidential, because if you can't demonstrate that you've maintained that information as confidential, you won't be able to stop someone else's use or getting damages if they disclose your trade secrets. Yes?
I have a question about the date. On here you say copyright 2006.
Yes.
Does it make a difference whether you put the date or not?
Yes.
It does. Okay. Because on photographs,
They don't always put it. You should put it on there.
On that score, every time you reissue, for instance, we have software, you should, for instance, 2001-2006.
Right.
You can continue on.
So when you load Windows, you see a copyright notice. It says copyright 1988 to 2003, I think, on my version.
So every time we issue a new version, it should be updated to
Yes.
the current.
And the reason that's important is it defines the term of the copyright. Copyright, I think, is 100 years for a corporate or an owner that isn't a person, or 75 years plus the life of the author, which is a really long time, but you're required to put that notice so that people know how long the copyright will last. And the reason that you update it is that if you're putting in new material, the copyright in the new material is later. So in Windows, for example, it's going to expire over time. So if somebody took the latest version, they'd still be infringing it even 85 years from now.
You're talking about the NDA and the confidentiality agreements. These tools are not that airtight.
No, they're not.
And so that's why I never considered even using them. What's the most airtight?
Don't tell anybody. But at some point, you have to tell people. So confidentiality agreements and assignment agreements are pretty good. So if you have employees that enter into confidentiality agreements where they agree not to disclose stuff, if they do, I mean, you can't stop people from doing it, but if they do, there's a pretty dramatic remedy. You can get an injunction, and you can probably stop whoever it is that's using it from continuing the use. Typically, the place you see it is with former employees starting a new company, and you can get an injunction that effectively puts them out of business. So that actually isn't a bad remedy. Non-disclosure agreements are a lot harder to enforce. If you're careful about inventorying the information that you've provided and marking everything, and somebody discloses it, you can make a case, against them for disclosing it if it really was a trade secret. You really don't want to be in that position if you don't have to. So what you'd like to do is disclose the minimum that's necessary, but at some point, if you're going to do a transaction with someone, they're going to, particularly if they're using your technology, they're going to want to know how it works. and they're going to want to look at it in pretty close detail. I think on the investment side, it tends to be a little different because they're more interested in whether or not you seem to know what you're doing and have a model that's going to work and your technology works, than in going through and rerunning everything. But I've seen very prolonged negotiations where a company will keep demonstrating whatever its product is or its technology, and they're do it under a non-disclosure agreement, and the deal will break down after a year's disclosure, and then the company that got all that disclosure independently develops something really similar. So you have to know who you're dealing with. And there's not a good way around that other than getting a sense of when somebody's asking you questions that really are just to get the information for themselves rather than do any kind of a deal. So that's what this slide was about. The other thing is to be careful about how long the restrictions on use last. A lot of times you'll see restrictions that continue without any definition at all, and or 5 or 6 years. That's a really long time. So if you enter into a non-disclosure agreement and you're getting someone else's confidential information, you would really like that to lapse sooner rather than later, even if it's not in the public domain. So a couple years maybe. Let's see. So if this slide seems repetitive, it's supposed to be. This is the place where I see the most mistakes. People never put copyright notices on their materials, and they very rarely register them. And it's really worth doing that, and it's simple and inexpensive. So I won't bring it up again, but hopefully I made that point.
Company confidential. Do you still need to have a copyright?
You don't have to if you mark it as confidential, and the people who you give it to acknowledge that it's confidential. You don't need to do that. I would put the copyright notice on it. It doesn't have to be on every page. It's just got to be at one place on whatever the work is. And the reason that it's useful is that if somebody copies it, it's a pretty easy case. If you can show that somebody has copied part of a work, whether it's software or a design, it's kind of self-executing rather than having the proof problem of whether or not something really was maintained as a secret or whether or not it was in the public domain. Because copyright only covers things that are substantially similar to your work. Somebody can look at it and get the idea and do it their own way using the idea, and that's not a copyright infringement. But sometimes people are lazy and they won't do that. They'll just take whatever it is you've created.
Can you store that text on a website?
Yes.
I mean, you don't have to file anything separate. You just put that text on it.
File it?
Well, I'm saying the copyright at copyright 2006. Can you just put that on a website? You have to file something before you get the privilege.
No, you can use that notice. Yes.
Okay.
And the requirement for whether or not something's copyrightable is it's a low threshold, whether or not there's any original content in it. So, I mean, 15 years ago, or 20 years ago, the big issue was with AMD and Intel was whether or not microcode was copyrightable, where there are almost no variations possible in how you write the microcode, and they found that to be copyrightable. If you actually have words, and the words are different, or a design, it's copyrightable.
Where you put it in each module, the copyright heading? Or do you need to?
You don't need to. I mean, if I guess it depends on how you deliver the software. I would. It doesn't, it's easy to do. But that's sort of my business, and I'm on the end of enforcing these, so it's always easier if you have the notice all over the place and you can say, geez, anybody would have seen it. If you're sending it on a CD, you can put it on the CD. If it's just downloaded, you can put it on in the code itself so that when it loads, there's a copyright notice. If people load different modules, it's probably worth putting it in the different modules. I mean, frankly, I think almost anybody loading software must assume that it's copyrighted. I mean, I don't know how you could. I mean, people that are using computers are usually sophisticated enough to know that there is something that governs ownership of copyright, even if it's open source. Somebody owns it. It's not as if it's that there's no copyright owner. You may give other people permission to use it, but you still own it. But I'd still put it on there because it's so easy. Yes.
How restrict are these copyright protection? And for instance, if they, let's say, one of these contract temporarily, if people re-edit that and then use that, is that violating copyright?
Depends on how close it is. I mean, it doesn't have to be exactly the same. So it's substantially similar. So I think it, you know, if you can show that it's clearly derived, that's probably close enough. I mean, if somebody reads it, puts it down, or closes it and goes and writes their own version, it's probably not going to be a copyright infringement unless they're the ones who wrote the original version, and there's so much there that it's clear that it's derived. But if somebody, you know, sort of just changes words, that's not going to do enough.
What about the purpose of that? For instance, today you distribute this one, right? The user may think that, okay, the purpose is for me to use it.
I would never assume that unless somebody tells you it's okay. If there's a copyright notice on it, I think you have to assume that you can't use it. You can look at it, but you can't make copies of it. Yes, you can.
Patents. So I'm thinking specifically like on software user interfaces. Is there sort of a rule of thumb on what types of elements there would be copyrightable versus patentable? And you know, as a startup, would be certain things that you'd want to protect.
It's really hard to protect a user interface anymore with copyright. I mean, and it's also really foolish to copy somebody else's interface. If you change it a little bit, you don't have an infringement problem. I mean, there was a big deal 15 years ago about look and feel in interfaces, and people asserted that, you know, if you used a trash can for files you were getting rid of, that was a copyright infringement. And the way the law came out on that is that, you know, if there are a limited number of alternatives, people need to use those alternatives, so the copyright protection you get is pretty narrow. I think, frankly, most companies don't ever face those kinds of claims because they're smart enough to change the icons. So it's very hard to protect a user interface unless it's really unique with copyright. And it's not that easy to do it with a patent either. I mean, you have to demonstrate that there's some utility there that's not obvious. And it's, frankly, an uphill battle because the patent office now is really gun-shy about issuing patents on user interfaces or business methods. I mean, there's certain areas where there's been an uproar when people have enforced those kinds of patents. That's one of those areas. So I wanted to talk a little while about what kind of patent strategy you might have. For small companies, a lot of times you aren't sure where the technology is going to go, and provisional applications are a way to get protection without spending a lot of money. Well, I think they're airtight in the sense that if what you file is sufficient to disclose the invention, it gives you a priority date. I think, you know, there isn't anything that's airtight in law. You know, there's always an argument about why they're not entitled to the right they've got. I'd feel more comfortable with a provisional application than with an NDA. But they're worthless unless you actually get a patent that is enforceable. So a provisional application just gives you priority in inventorship. You can demonstrate that. And it's never examined. But they're very inexpensive to file. And if things are changing over time, you don't spend a lot of money on filing patent applications on features of your technology that end up not being very worthwhile. So we file a lot of provisional applications for smaller companies because they're cheaper and they make a lot of sense because it's hard to know what the final product's going to look like. If you file a provisional application, you have a year in which to file a non-provisional, which is a real patent application that gets examined. The only trick with provisional applications is that the disclosure standard is the same as for a non-provisional. It has to be enough of a description of what the invention is that somebody who reads that, who works in that area, will be able to reproduce the invention. So if it's just a very brief description and it's not sufficient for somebody who's of ordinary skill in that area to make the invention, it won't be enough. And that's true of unprovisional applications as well. But typically, if you have somebody who's drafting a non-provisional application for you, you'll have somebody who's more aware of what the disclosure standards are. No, they're never published. And actually, non-provisional applications in the United States are never published either unless you decide that you want to file foreign. They didn't used to be published until they were issued. But about 5 years ago, the law changed so that now if you file a non-provisional application in the United States, it'll be published 18 months after the U.S. filing date. So if you file a provisional application, you have 1 year in which to file a non-provisional. It'll be published 6 months after the non-provisional date, 18 months after the original provisional filing. You could elect out of that if you don't file foreign. So in the United States, you can keep it confidential, but if you decide that you're going to file foreign rights, it'll be published at 18 months. So you need to decide whether or not it's a technology that you're going to be able to protect well enough with a patent that it's worth having it disclosed for other people to see. And sometimes make a decision just to maintain it as a trade secret rather than having it published. On the other hand, if you get a patent and it covers something that's worthwhile, it can be really valuable. I mean, it's good if you're negotiating a deal with somebody else, and it's kind of hard to enforce a patent if you're a small company against other companies because it's not inexpensive, but at least it gives you something that is a tool for later on. You don't have to enforce it right away. Foreign patent protection is even more expensive than filing in the United States. So if you file in other countries, you want to be really selective about where you file. I think I said that filing an application in the U.S. is usually between $20,000 and $30,000. Just doing the filing, not the prosecution or paying the maintenance fees, in Europe and in Japan costs about $8,000. So those are just the filing fees, and then it'll be examined. So over the life of the patent, getting it issued and paying the fees, it's probably between $50,000 and $100,000 for both Europe and for Japan. Korea, Taiwan are lower than that, but they're still really expensive. China's pretty inexpensive right now, but nobody knows what those rights are going to be worth. So we do lots of filing in China, but I don't know of anybody that's enforced a patent in China. On the other hand, it may be one of those tools that if you're negotiating a deal, it's useful to be able to say, we have these patents. And, you know, in a lot of countries, that's what it ends up being anyway. In the United States, lots of companies do cross-licenses, or they just decide that they'll leave each other alone because they know that both parties have patents that could be enforced.
In Japan, it's the first to file. So what are the consequences if you don't file a foreign patent? I mean, do you have to deal with Japanese or Chinese competition?
Yes. So if you don't file, and it's your invention and other people are using it, there's nothing you can do to stop them. So maybe you just have to beat them in the market. If they have patents on their own technology and you don't have anything, you're at a real disadvantage. So sometimes it makes sense to file. You sort of have to identify the markets that are most important and decide whether or not it's worth filing in those countries. And it's not an easy decision. I mean, to a large extent, is speculative about what the technology is going to be worth in 5 or 10 years.
Sounds like you said 8,000 in Japan and Europe. Wow.
Mm-hmm.
Quite a bit less than what it costs here in America.
No, it's $8,000 in filing fees. In the United States, the filing fee is about $1,000. Pardon me?
20 to 30,000.
To write the application and file it. So the cost isn't in the filing fee with the patent office. The cost is in having somebody do the work for you. So if you figure, with most patents, it costs about half of that amount to get it ready to file, to write it and to pay the filing fee. And then 2 or 3 years later, or 4 years sometimes, depending on the technology, it's examined, and they'll always reject the application unless you've written the claims too narrow, because the examiners don't have very much time to look at patent applications. They have 3 hours to examine it. So they look at the pictures, they look at the claims, and then they go do a search, and they find the closest thing that they can find in the U.S. Patent Office in issued patents, and they'll say, it would have been obvious to make your invention because these 3 patents show the same thing. And examiners get evaluated based on how many cases they dispose of. So that's how they get a disposition. They basically say, here's the closest thing I can find. You tell me why your invention is different. So you spent $15,000 filing the application. Well, in 2.5 years, you have to respond to the patent office and tell them why your invention's patentable over whatever it is they cite. So you need to go in and evaluate the prior art and tell the examiner why your invention's different. And if they found good prior art, if it's a good examiner, then you can rewrite your claims so they distinguish whatever it is that's shown in your invention so that it's different, so the claim language reads differently. So that process of responding to the patent office and then paying the issue fee and getting formal drawings is going to double the cost. So half of it's kind of in the filing, and another half of it's 2.5 to 3.5 years out. You go through that same process in Japan, and in Europe, it's examined. Generally, the examinations are a lot better in Japan or in Europe than they are in the U.S. because their examining cores are better. In the U.S., it's not a very well-paid job, and they have a lot of turnover. In Japan and in Europe, they have professional examiners who are pretty well trained, and they tend to find better art, and they know what they're doing. They'll also tell you what they think is patentable. You don't have to read their minds. In the U.S., they very rarely will do that. So you get a pretty good examination there. If you have it examined first in the U.S., you can use a lot of the arguments you've made in the U.S. and the other countries, which is part of the reason it makes sense to defer examination in other countries. So then you go through that process in the other countries where you've filed. Japan and Europe give you the best examinations. In Korea and Taiwan and China, they do fairly independent examinations. Other countries tend to look at what happened in the U.S. or the European Patent Office and give you a similar kind of response. So you show them what's happened in the U.S., and usually they'll follow that. So in Canada and Australia are the ones I'm most familiar with. There's not a lot of independent examination.
So where was that question? So it sounds like the cost and even now you're mentioning the quality of the examination. Would it be best to go to Japan or Europe first? And also because some of the manufacturing is over there as well in Asia. It may just be best to just do everything there.
I wouldn't go to Japan because the examination takes forever. Europe takes a pretty long time. We tend to, obviously we file in the U.S. because we're closer and we know how it works. For some companies that might make sense. If I were going to pick a place just in terms of getting a patent issued quickly with a good examination, but quick is a relative term. I mean, if you file first in Europe, it might be 3 years. It's not going to be a quicker examination, but it might be a better examination on the first time around. I think it makes sense to file in the U.S. just because of the size of the market here. I mean, there aren't many products that are of commercial significance where there isn't a major market in the U.S. And You can go to court and enforce patents in Europe, depending on the country you're in. Germany and the UK are good countries to enforce patents, and you have to get it issued in each country in Europe. Once it gets through the EPO, European Patent Office, then you get the opportunity to pay the fees in each of the countries where you want it issued. So you have to pay for translations too. And then if you enforce it, you have to go into the courts in those countries. So it's non-trivial. There isn't a European patent court.
But you were going to say you could file it anywhere outside of the
I'd file it in Europe if I were going to file it someplace else. I mean, it depends on what you want. If you want a patent really quick, maybe you go someplace where you get a crummy examination, but then somebody else has got the burden of demonstrating that the patent's no good. You know.
Yeah. I have a scenario I'd like to give you advice on that regarding to patent infringement case. Let's say there's a small startup company in Silicon Valley invented a new innovative product that's threatening the dominance of the multinational company. So, of course, the large conglomerate company is going to file a lawsuit to have an injunction for a small company not to be able to sell the product. And then for a small company, can a small company in Silicon Valley actually go to either license or purchase the patents, let's say from Stanford University's portfolio, that this multinational company actually violated? So use that as an enforcement to counter-attack the multinational company.
Well, you can if you get the rights to enforce, but
So what kind of the right is necessary?
you need to own the patent or have an exclusive license. So if you go to Stanford and say, I want to get a license to your patent, and sorry that this lady left who works in the technology licensing office. Typically what a university will do is grant a number of non-exclusive licenses, and you don't have the right to enforce the patent if you have a non-exclusive license. So just getting a license isn't going to be enough. You'd have to go persuade Stanford to sue for you. They're probably not going to be excited about that.
So, what about exclusive license? Is that sufficient?
Yes.
That's sufficient.
If you have an exclusive license to a patent, it's essentially the same thing as owning it.
Is there any possibility you just have to own the right of the license, right of enforcement? Is there such a term as
No.
useful? No. Because these patents is not useful for this small company. Someone can still license it to someone else as long as it's not licensed to a specific company that has required lawsuits.
Pardon me?
What I'm saying is that all the small company needs the right to enforce.
I'm sorry, I still didn't understand.
What I'm saying is that for the small startup company, all the company need for that technology is the right to enforce the license. Right? The right to enforce means that if one violates the small company.
Yeah, you can get that. It just has to be characterized as an exclusive license. If you have an exclusive license, you can grant sub-licenses. I mean, there are ways to do it. You could go to Stanford and say, we want an exclusive license to your patent subject to all the licenses you've already granted.
Exclusive license for the right to enforce it.
But there isn't a separate right to enforce under U.S. law. You have to have ownership of the patent, and an exclusive license is treated as having ownership. So you've got to have one or the other. Otherwise, the federal judge will just tell you don't have the rights that are necessary to enforce the patent. And then,
So you're saying that exclusive right, the exclusive license is the same as owning the whole.
Yes.
No, I just talked to this lady. She said that Stanford never sell the patent.
That's right. Stanford's not in the business of having their licensees go sue other people. It poisons the market.
Stanford does give you exclusive license.
Sometimes, for a limited term, and they'll do it with a royalty that escalates over time, so there are restrictions on it. But yes, they will give exclusive licenses to technology that hasn't yet been commercialized in order to help a startup company.
I have a question. So if I start a company and we're moving forward and we set a name and have a website and building software. Not just there's less things we can do to protect our property. But is it worth devoting the resources, whether it's time or money, to seeing if we're going to infringe on anyone else's rights? So do I need to do a trademark search or a patent search to see if what we're working on someone's already?
I would do a trademark search just because it's fairly simple. You can go to the Patent Office website, and the trademark side of that, there's a search logic you can use, and you can get a sense of whether or not somebody else has registered your name or your product names. I think it's worthwhile to look at what your competitors do. If you do a patent search, there are a lot of patents, 6 million in the U.S., and trying to do a search without knowing what you're looking for isn't very fruitful. What you're better off doing is looking at what your competitors are doing and seeing. You can look on the Patent Office website for assinees so that you can see, run your competitors' names, see what they've got patents on. Because it's nice to know if you're filing patent applications, what other people already have, and if you're developing a product, to engineer around what patented technologies might be. So I think it's worth and frankly, I don't do patent searches for companies that are pretty savvy, with people who know the technology, because what they know is going on in the market is a lot better than anything I'll find in a patent search. Although if those folks look at the Patent Office website, they may be able to find stuff that I wouldn't. Some people think you shouldn't run patent searches because then you're on notice that you might be infringing, but I'm not sure that's a good strategy, because you could spend a lot of effort and then find out later that you're infringing somebody else's patent. Yes?
Do you know that you were doing a patent search?
They don't know.
Oh.
Well, maybe the Patent Office knows, just like Google knows what you're looking at, so somebody could find out that you were doing it.
A quick question on point. You were talking about the patent being rejected unless the claims are very narrow.
Right.
And so that's really where you want to be.
Yeah, the rest of the disclosure doesn't mean anything. So lots of people read a patent and say, I can't believe that they got a patent on this. Well, go to the claims, which are numbered at the back of the patent. And usually they'll have some esoteric language that's pretty hard to follow, but if you work your way through those and understand them, you'll see what the patent covers. And just in terms of what it really covers, you can now, on the Patent Office website, you can get the prosecution history online. So for the last couple of years, once a patent is published, the prosecution history gets published too. So if you haven't filed a non-publication request with the Patent Office, all of the Patent Office rejections and your responses will be available to the public. So if you're looking at, and once the patent issues, that'll also be available. It used to be you had to send in for the file wrapper. They're called file wrappers because they have two sides that fold in the middle. And most people call it a file wrapper, but it's the prosecution history. What's going on that you submitted, what the Patent Office said when they rejected it, what your response was. And if you want to understand what the claims really mean, you have to go and see how they were changed and what arguments were made about why cited prior art is different from your invention. So, and that's now available online at the Patent Office website, so you can get all of those documents. And that's very helpful.
Is that available for trademarks also?
Yes. So,
Is that also available for the patent that was filed 10 years ago?
no.
So when was the cutoff?
Well, I think they started publishing applications in 2000, and they weren't online yet. So you can probably get stuff about to 2002. Yes.
2002?
Yeah. Otherwise, you have to order it from the Patent Office. And if you want a copy of the patent that's a whole patent, it's really inconvenient to get it off the Patent Office website. But once you've got the Patent Office, or the patent number, go to pat2pdf.com, P-A-T, the number 2, PDF.com. I think it's .org. One of them charges you for it, the other one gives it to you free. And I think it's .org. because it's really nice not to print it out one page at a time. Anyway, if you can't search on that site, but if you got the patent number, you can get a PDF, and then you can look at the pictures, because the Patent Office website, you can print them off, the real patents, one page at a time, but if it's 40 pages long, it's really tedious. And if you just pull it up, you get just text with no pictures. So.
Where I'm going with that about the claims being-
Sorry.
No, is, in your experience, when you've seen applications rejected, is that because of the claims being, for example, well, we're using the terms like bells and whistles, it's really not a substantial part of the patent, but they've added so many other things trying to cover a lot of real estate?
Well, yeah, when you look at the prosecution history, you can tell. So if somebody's if you have a claim that's this long, you only have to avoid one of those elements, and if it says, use a yellow this or that, there may be things written in there that make it almost impossible for anybody to infringe it or make it really easy to engineer around. If you look at the prosecution history, you can tell, because it'll get very specific. And you don't always find that, but often enough you do find a way around it that it's worth looking. I mean, just my guess is probably 2/3 of patents, there's a fairly clear way to engineer around that you can come up with just from the prosecution history. But those aren't likely to be asserted against you. Sometimes they are, but at least you have a good argument for why you don't need to bother with them. I think my time's up. I was going to talk a little bit about trademarks and about trade secrets, but there are write-ups in these materials about both of those. So I won't keep you longer. If you have questions, I'm happy to answer them.